Thank you, Awa, and thanks always to the team that makes this possible. It's my great pleasure today to open up the series of the conversatory on rights around the world with the fourth and last speakers on Israel-Palestine, Smadar Ben-Natan. Smadar is a longtime Israeli human rights lawyer, 18 years of practice plus, completed her PhD in Tel Aviv University. She's a postdoc at the University of Washington. She was a visiting scholar at the Center for Middle Eastern Studies and the Center for the Study of Law and Society at the University of California, Berkeley. She specializes in law and international law with particular focus on intersection of criminal justice, national security, human rights, I would say political sociology as well. We're going to discuss in part her doctoral dissertation today, but I want to focus more, and I want to say that Smadar is a practitioner of law. She has defended Palestinian rights, prisoners' rights, gendered refugee and asylum seeker, and she's the first, she's the co-founder of the Gun-Free Kitchen Tables, the first Israeli gender-related gun control initiative. She is a practitioner who uses her practice to think about it and reflect, to then create that knowledge to go back and redress practice. It's a pleasure, Smadar, to have you here today.
It's really a pleasure to be here, Mara, and thank you for this wonderful introduction.
So as you are aware, we've been discussing different issues of the Israel-Palestine conflict to condense it in the common way it is, you know, portrayed. And what you do is go to the nitty-gritty of how this conflict, you know, plays out in law on the ground. So I would ask you to you unravel, right, like the system that is not contingent and it's non-anomalous, but you take it as a whole. Can you take us there? You know, what is the core of your argument and how you started with the law military court?
Okay, so as you correctly say, I do study issues that are related to the Israeli-Palestinian conflict. But unlike many other scholars and lawyers and politicians, I don't see the Israeli-Palestinian conflict as something that is only external to Israel. That is an external problem that is going to be solved within negotiations with the Palestinians, and then Israel will, you know, finally have a normal political system, which, you know, I don't know if that exists. So I don't think Israel is very, very special. It has its particular problems, but any country that is defined as a nation state has these underlying issues where the nation does not correspond or does not match one-on-one the territorial boundaries of the state and the population of the state. So the mismatch between the idea of a nation state, that where the nation is a homogeneous group that corresponds one-on-one to the territory and the government of the state, that exists in any nation state, to my mind. So I'm not an exceptionalist when I look at Israel, but every context has its particular history and the particular configuration of questions of citizenship rights and other rights of that population. And so I always look at Israel and Palestine, which I use when I write with a slash, Israel Palestine, as a single political unit, because there's one state and one government that controls this entire territory. And I say that, and you mentioned that I'm a practitioner, this does not come from me as a political agenda. It comes from my experience. So I was a lawyer, and as a lawyer, I practiced law in Israeli civilian courts inside Israel and in Israeli military courts in the occupied Palestinian territories, and I could constantly see the continuities and the things that are the same in both areas and also the differences. So I have this image of this entire political community that comes from my experience and my practice. So I started with studying the Israeli military courts in the West Bank mainly, where I practiced, but not for a long time because it was so different from practicing law the way I knew it in Israel, and I was having really hard time being there. But this is the focus of most of the scholars, because nowadays, and since 1967, the military courts in the occupied Palestinian territories are responsible to prosecuting thousands of Palestinians each year, and about 1/3 of the total prisoner population in Israel are prisoners that have been convicted in these courts. So they are important, and they manage a large caseload of cases, but they are considered as exceptional and as a result of the 1967 occupation. So they are regarded as an exception to the democratic, regular, ordinary justice system of Israel, because they are part of an occupation. An occupation is regarded as temporary, and they are regarded as a temporary security measure that once the Palestinian-Israeli conflict is resolved, they will go away, and they are a security measure. And when I started studying it more historically and more in context, I actually discovered that it was not the right way to see these courts. They are not exceptional, since Israel has been using military courts ever since 1948. And Israel actually is not the first to have introduced military courts in the region, because the British Empire had introduced military courts in order to face resistance to its imperial rule, not only in Palestine, there was under British mandate, but also in India, in Ireland, in Kenya, and many other British colonies. And Israel built on this legal and bureaucratic infrastructure of these courts and continued them also after its independence. So between 1948, I'm finishing up. Between 1948 and 1966, Palestinian citizens of Israel were prosecuted in military courts as part of a military regime that they were placed under. And these courts stopped operating around when the military regime stopped or was terminated in 1966. And in 1967, military courts were active again since 1967 in the occupied Palestinian territories. But what most people don't know, and what I focus on in my research, that in 1967, there was another military court that was established inside Israel. So in that court, Palestinian citizens of Israel still were prosecuted with Palestinians from the occupied territories and from other Arab nations that got there in several ways, but they were still, Palestinian citizens were still prosecuted in a military court inside Israel until 2000. Until 20 years ago, that court was operated, and they did not have an equal treatment under the law, because their security offenses were prosecuted in a military court. So what I show is, one, that there's a continuity of military courts since the British mandate and on, and also that it does not depend on citizenship status. So whether you're a citizen and whether you're not, if you were Palestinian, you would have been prosecuted in a military court up to 2000 in Israel, Palestine.
There is a lot to unpack there. Thank you for this, very, very, very dense introduction. What you're claiming is that, on the one hand, the conflict is not external, Israel-Palestine, but it is internal at the very core of the polity that you take as a whole, and not in different parts. That is the only way to understand. And also that there are continuities that are usually not kind of seen. One very important continuity is between British colonial rule, and Israel, and between Israel and the occupied territories, another line of continuity. And also, before 67, where military courts were mostly kind of land issues, if I understand correctly, and after 67, security issues, right? So what you're saying is that this is built in at the core. And I would like to ask you if you can explain, the difference between a civil court, just to have, the concept rise for the audience, between a civil court and a military court, and also who are these Palestinian citizens of Israel, and what are their rights?
Okay, so I think I don't need to explain too much what are civilian courts. These are the courts that we are used to think of as the courts of the central justice system of the state. And we are used to thinking that in a democratic government or in a democratic state, people are entitled to equality before the courts and equality under the law. So everyone would be under the same system of courts and the same system of law. Military courts, on the other hand, there are several types of military courts. So there are what we call courts martial that are responsible for prosecuting soldiers. I'm not talking about them. So these are the internal criminal mechanism of the military itself. I am talking about military courts who prosecute civilians. And when we have a system where some citizens or some subjects of the same government are prosecuted in civilian courts and some are prosecuted in military courts, we have a violation of the equal treatment under the law. And why is it a violation? Because military courts don't give the same treatment. And this is part of what you were asking. What's the difference? The difference is, first of all, that military courts are not as independent as civilian courts, okay? We think about the separation of powers. We have a judiciary, a legislative, and an executive branch. And the judiciary is independent from the executive. And that's one of the core issues about having a judiciary. The military courts are part of the executive. They are not independent like civilian courts. Judges don't have the security of tenure and many other factors. I won't get into it, but they don't have the basic features of an independent judiciary. That's one level where they give unequal treatment under the law. The second component is fair trial rights or due process rights, as we call them. So because military courts originally are part of military discipline and military hierarchy, they do not afford the same protections as civilian courts afford to defendants or to people under them. So just to give a couple of examples from nowadays military courts in the occupied Palestinian territories, people are detained for a longer period of times. They can be denied meeting with counsel for longer periods of time. There are different limitations on their ability to question witnesses and many other issues that I don't want to go into too many details, but traditionally and over the years, the due process rights in military courts are far less than in civilian courts. In more remote history, the judges were not even lawyers. So these were military officers that used to be judges in military trials until not very long ago. So the panel of judges would be two military officers that had no legal education. So their understanding of the rights of the defendant was very limited, and so was their independence. So in all those senses, military courts do not afford the same protection. And because they are part of the military, they institutionally give more weight to security considerations over considerations of the rights of the defendant. So it's a court that is inclined to rule or to decide in favor of security and not in favor of civil liberties when these two clash.
How are the cases assigned to military courts? Because, in the Palestinian territories, I mean, you're claiming that these are exceptional, but exceptional in a way that they are part of a constitutive whole that has, a goal. in having the system as it is. But how are they assigned to the military court that you worked, that you used to illuminate issues of wider importance, so to speak, the Lord military court? Because these are civilians, right? These are Palestinian citizens of Israel that should be assigned to a civil court, right? But instead, they are assigned to a military court. So why is that the case? And why is it important?
Yeah,
also?
okay. So there is a difference in this sense between the Lord military court that used to operate in Israel and the military courts of the occupied Palestinian territories, in the sense that in Israel, it was a harder job to kind of decide which case goes where, because everyone were citizens, right? There was no specific classification like there is in the occupied territories. Someone like settlers are citizens of Israel and Palestinians are not citizens of Israel. And we will come back to that.
Mm-hmm.
Then there needed to be a system for sorting out the cases. And that was one of the main questions that drove my research. And my final answer is double. So first of all, it was institutional. So the body that was responsible for deciding that is the security service. It's not the Ministry of Justice, it's the security service and the military. And because the security service saw Palestinian citizens of Israel as a security threat or as a category of targets, okay, for security concerns, this was any case that was dealt with by the security service was transferred to the military prosecution, and this is how it got there. But what I, in addition to that, found out is that the security service itself and all the officials in the military prosecution and the military of justice used classifications of Jews and Palestinians. So there was a rule, an unwritten rule, but I have it on paper by the legal consultant of the security service saying there is no written rule about it, but the policy is not to prosecute Jews in military courts. So no matter, even if Jews were prosecuted for treason or for cooperating with Palestinians, terrorists, whatever, they would not be prosecuted in a military court. And actually, the same rule applies to the occupied Palestinian territories, where settlers who are Jews are prosecuted in Israeli courts, and Palestinians who are non-Jews are prosecuted in military courts.
So that's very illuminating, because what you're claiming is that even though you have the formal kind of status of citizenship, let's think about Palestinian citizens of Israel, that many times, the argument is, I'm going to play a little bit, not the devil's advocate, but, they're like full citizen, regardless of, 60 plus laws that do not grant, equal access to law, but they can be elected and elect, right? And they can be members of the Supreme Court. So what is the difference? And what you're arguing is that even though they have a formal access to, to citizenship, there is a symbolic kind of access in that they do not belong. They are seen as other, and there is this ethno-national sorting that goes along, Israeli Jews along civil courts and Palestinian citizens to military courts. How did that play out in the law military court that you worked on, that I find fascinating?
So the Lord Military Court was established in 1967, so not before. And this is why I define it as a boomerang effect of the occupation of the West Bank and Gaza and the other territories. So it's a boomerang effect of the occupation into Israel. So, and this is one of the reasons why I claim that you can't fully understand Israel if you don't look at the occupied territories and vice versa, because you can't understand how Israel established another military court inside Israel in 1967, regardless of the occupation. So it had a boomerang effect. That boomerang effect was created, at least partially, by the annexation of East Jerusalem. So right after 1967, Israel annexed what it calls East Jerusalem with 70,000 Palestinians that were Palestinians from the West Bank. There was no difference between them and other Palestinians from the West Bank, but they did not become citizens. They became residents of Israel. And the first few cases in the Lod military court, and the case that that prompted the establishment of this court, was a case of East Jerusalemite Palestinians who tried to explode a cinema in Jerusalem. So it was attempted attack in response to the occupation. But they soon enough, other Palestinian citizens of Israel were also prosecuted in that court. So what happened is that if you were a Palestinian from wherever that was arrested inside Israel, if you were a citizen or not, you were prosecuted, you were interrogated by the security service or the military interrogators and prosecuted in this court. And the trials were very swift. They ended in one day in most cases. One of the things that we should understand about these courts, that it's not only about the courts. If there are interrogations by security services, they result in confessions in most cases that are obtained in different ways, some of them with physical pressure, and certainly at that period with physical pressure sometimes amounting to torture. And the law is set in a way that it's really, really hard to have a normal legal procedure or to prove you are innocent, because the prohibitions in these laws, in the military laws, are so all-encompassing that kind of everything you do, if you are a Palestinian and you're connected with someone who talks to you about something, would comprise of an offense. So people were prosecuted in this court in very summary proceedings and sentenced to very harsh punishments. Some were sentenced to light punishments. So there's an aspect of political control in these courts. It's not all about terrorist attacks and bombs and shootings. Many of these cases are just, you met someone who is indirectly connected to that organization, and therefore we prosecute you and you will sit in prison for 3 months or for 6 months, not long time, but you know that you shouldn't do it. So it's political control and suppression of political resistance that is taking place there.
So what you're proving, not only kind of arguing, but you're proving that instead of the judicial system of being based on the assumption of innocence, it's based on the assumption of existential threat, right, to the security of Israel. And once you assume that, you can only prove it. It's a kind of self-fulfilling thing, because in as much as you're going to pose the other as a threat, the other then is going to turn, against you in general terms.
Yeah.
So you work here on the category of citizen enemy. And can you tell us what that idea is, where it comes from, and what it illuminates about the judicial system that we have, in Israel?
So actually, I may tell it in the way that I got to it that would make it more comprehensible. So when I started this research, I wanted to see how enemies are treated in the legal system. Because in the criminal system, an enemy it's not a formal definition. There's not a legal definition. Anyone can be charged of anything, regardless if you're a citizen, if you're not a citizen. But I had a sense that enemies are being treated differently because they're not part of the political community. They don't have the same obligations towards the society they live in. They are external. So I had a conception that, and I'm not the only one, of course, that enemies were external to the states. They were non-members, and I wanted to see how they were treated. And when I started investigating that, I stumbled on citizens. So I discovered that in this court, that was a court that was designed for enemies. It was a military court. The military justice the military is expected to confront enemies, and it uses rules that are enemy-like, that do not treat people as members of the society, but as an external threat. That in this court, citizens were also regarded as enemies, and not only non-citizens. So this is, and there are many articulations of this idea of being regarded as an enemy while you are prosecuted in a military court. So one is the symbolic element and the institutional element that I just pointed to. This is the idea of the military, but also as a legal scholar, if you look at the law, it's a different law that is applied. So, and there's a term coined by a German legal scholar that is called enemy criminal law. So he argued that any justice system, he talked about Germany, it's a double legal system. There's a law for enemies and there's a law for citizens. And the law for enemies is more coercive, more preventive. It affords less rights, and it inflicts harsher punishments. And this is what you see across the military law in every military court that I looked at. So these people are treated different. They are citizens, but they are treated different than citizens in the terms of where they're prosecuted, and they are subject to a law that is inherently an enemy type of law, a law that is designed for enemies. And this is why I call them citizen enemies, because they are formally citizens, but they are in these institutions, or by these institutions, they are treated as enemies. And they don't cease to be citizens. The citizenship is not revoked, if I'm speaking in American terms. It's not that they revoke their citizenship, they're still citizens formally, but then they're treated as enemies. And I argue that there are, although there is a formal citizenship, informally, there are different classes of citizens. We all know that. There are Class B citizens, right? There are citizens who are regarded as less or more belong to the community, but there's also the more extreme case of a hybrid kind of status of citizen enemies. So, and if you think about American history, think about the internment of Japanese citizens during World War II. So it's not, it's a category that can apply to different situations where Japanese were considered a threat only by virtue of their origins in Japan, although they were citizens.
I want to highlight that in the same way that you are being, of course, extremely critical of how the dimension of civil and military courts, operate in Israel, you're also saying that this is not exclusive, to Israel, and you see it, and we see it, in the US, and you are familiar with the work of Wudia Said, who was also here, in the conversatory last year, and he doesn't work about enemies, but yes, as foreigners, right? And it's the figure of the terrorists and the immigrants that are, assumed guilty before even being tried. And even though here there are no military courts in the same way, the kind of treatment is just completely, disproportionate, if I may use that word. So you don't oppose citizen to enemy. What does that say about the judicial system and the rights of Palestinians, and more broadly about how to understand the practice of that law?
So citizenship is a category with a promise, but that promise is not always realized. It means that we have to struggle for citizenship to have the meaning that we want to assign to it. This is what it means. So it means that there are different categories of citizens who are treated differently along different categories. So in Israel, the category of security is very prominent. And if I take a step, if I do another comparative moment between Israel and the United States, in the United States, you speak a lot about mass incarceration. And the language that is used in order to incarcerate large numbers of the Afro-American community is a language of law and order, okay? They are criminalized in certain ways, and the language that is used is law and order. In Israel, the same thing applies with national security. So Israel uses the frame of national security in order to criminalize and incarcerate large numbers of Palestinians. That is, in many senses, we could call mass incarceration, because it's an over-criminalization of a particular ethno-national group, and you see that along the lines of ethnic and national belonging. So the issue of security is very prominent in Israel. What I'm saying is that there are different meanings to citizenship. The first meaning is formal, whether you have a citizenship status or not. Then there is the aspect of rights, whether you have equal rights or not. And we want to think that citizens have equal rights, but in fact, they don't always have equal rights. The fourth aspect is of political participation, right? Of voting, of being able to vote. That is something, for example, that Palestinian citizens of Israel do have. They do enjoy the ability to vote and to be elected. I'm not trying to, we need to acknowledge also the promise in the status of citizenship and the participation that it allows. And the fourth aspect of citizenship is that of belonging and solidarity. So these are the promises of citizenship. They are not always realized. And it is a constant struggle to include people who are citizens, who we want to include in our political community, to have all these aspects of belonging in a society. Now, this is hard work. Okay, this is hard work, and it's very difficult in the Israeli situation, where the state defines itself as a Jewish state, and the common good is defined as having a state for the Jewish people. It almost by definition excludes Palestinians from this vision and does not enable the fourth aspect that I was talking about of belonging and solidarity and being part of the common good that the political community is imagining. In that sense, that is very hard to, or impossible to achieve with this set of definitions and of groups.
In the way that I understand, that I understand your work, of course, you're criticizing what the occupation meant in terms of the unequal treatment, of rights, but it is because it violates the equal rights of Palestinians, but also because what you were saying, it undermines the kind of the democratic and liberal basis of Israel as a polity, of the assumptions and aspirations of Israel as a polity. So what you're showing is that this is questioning, the democratic aspirations of Israel. What do you see? Can you give us examples? You work on two examples of an Israeli settler and a Palestinian in terms of how, their trials. I hope I'm using the legal jargon correctly, because I'm not a legal scholar at all. Can you give us these two examples so the audience can really grasp, how this plays out on the ground, that it's just not a performative or, a political slogan.
It's not purely symbolic, it's very real.
Right.
So I will just say that in many publications of human rights organizations, etc., you see a comparison between the rights of Palestinians in the occupied territories and the rights of settlers. And but then there's a difference of citizenship, right? Palestinians are non-citizens and settlers are citizens. What I do is that I give the same example from my research about the Lod military court with two citizens of Israel, so that the same disparities actually existed and still exist in different ways now that that court was abolished, although, it's better that it's abolished. from the 1980s. And I take two cases from the 1980s. One of them is Mahmoud Ziada, who was a Palestinian citizen of Israel and joined the Popular Front for the Liberation of Palestine, which was a terrorist organization. He threw a grenade over a bus that was full of civilians. He meant to explode that bus. The grenade did not explode and no one was hurt, luckily, but of course he intended for people to get hurt. So that is one case that I take. The second case is of Barak Nir, who is an Israeli Jewish citizen living in Jerusalem. And Barak Nir joined the Jewish Underground, what was known as the Jewish Underground. That was an organization of extreme radical right-wing Jews in the 1980s who murdered some Palestinian students, who hurt Palestinian mayors and were intending to explode the Temple Mount, a holy site for Muslims. And this group, all of them were arrested. Barak Nir drove two of his friends to the Islamic College in Hebron. His accomplices shot and killed 3 Palestinian students. He was waiting in the car. They returned to the car and he drove them back. So he was an accomplice to the murder of 3 by any standard and by the standard of the law. What happens to these 2 citizens? So Mahmoud Ziada is prosecuted in the Lod military court. He is accused of an offense where the maximum punishment is the death penalty. The death penalty that does not exist in civilian courts for these types of offenses at all. And he is sentenced to life imprisonment. Barak Nir is sentenced in a civilian court for murder and attempted murder. They're both prosecuted for membership in a terrorist organization. So both organizations are regarded by the state as terrorist organizations. And he is not under any risk of facing the death penalty. He is sentenced to 6 years in prison for what he did. So the punishment are really very, very, very different. So is the offense and so is the maximum punishment. And this is not the end of the story. What happens next? Barak Nir is his punishment is commuted by the president, like all the other members of the Jewish Underground, and he gets out of prison after 2 years. Ziada, on the other hand, spends 18 years in prison, and then he thinks, oh, I can go to a parole committee and maybe be released. And he's not being sent to a parole committee. He asked for a parole committee, and I'm cutting this short. An appeal to the Supreme Court says that, no, you're not entitled to a parole committee because you are in an indefinite life sentence. And the indefinite life sentence is only for offenses where the maximum punishment was the death penalty. So only someone who was prosecuted in the Lod military court under military law is actually never going to get out or go on parole unless the president commutes the sentence, and the president does not commute the sentence. So he's there for 24 years until there is a deal to return Gilad Shalit, an Israeli soldier that is captive by Hamas, and release other prisoners. He serves 24 years and released only due to that political deal. If it were not for that, he would still probably be in prison. So you see that it's not only the sentences that are different, it's the law that is applied to them that is different. It's the death penalty that is there and determines that the life sentence is indeterminate, and you have this 2 years versus over 20 years, which could be much more.
And I'm speechless, but in rage. And we go back to the point that these cases are allocated not because of territorial jurisdiction, not because of the subject matter, but strictly along ethno-national, ethnic lines.
Yes.
right? So we can say, is individual justice possible for these cases? But what you're saying is that even in Viciada case, if there had been individual justice, what we still have is a collective system, right? Like a system of legal mechanisms that sort out demographics along the lines of assumptions based on identity and demography. And I want to ask you, as a human rights lawyer and scholars, actually, reflecting on these issues. When you treat a case, in terms of human rights, citizenship rights, you want to give a fair treatment to the defendant, but at the same time you see this in the bigger picture, right? That is the political context. Can you talk about this tension or not tension, between someone who, yes, wanted to hurt people, like you pose with the case of Ciala, but at the same time who's being criminalized and is the subject of crimes on an ongoing basis by the state of Israel, let's say, or by legal mechanisms?
Yeah, well, I think that one of the ways I think about it, and this reflects a little on my practice and my frustration with my practice. I was able to change many individual people's lives and affect them for the good, and that was very, that was a sense of fulfillment in my work. But the legal system is really meant to deal with individual cases and does not deal well with collective issues. So it is not, it's built on a liberal framework, at least the criminal justice system, that looks at the individual and what he or she did, and not at the larger context of what is being done here. And as a matter of practice, as a practicing lawyer, it's very hard to affect the bigger picture, even in, more constitutional law or administrative law cases. The bigger the case is, the harder it is to win it. And the smaller the case is, the easier, not that it's easy, but there are better chances to win it. So the legal system is not the best way to bring in structural change. Structural change is a political manner, and we've got to tackle political issues as political issues and not try to convert them to legal issues, because the legal aspect does not solve the entire problem. And maybe an illustration for that would be what we talked about today about the Lod military court. So there were attempts to challenge this. There were Palestinians who petitioned the Supreme Court and said, we are being discriminated. Only we are being prosecuted at the Lod military court. Why shouldn't I be prosecuted in a civilian court like Jewish citizens? And they were all dismissed by the court. Said, well, the prosecution has a discretion where to prosecute you, and you don't have an invested right in being prosecuted here or there. The change came from the military. The change came from different perceptions of what does it mean to be a citizen, which rights are citizens entitled to, and from criticism from other countries, from delegations of human rights organizations that would come and ask, why are we prosecuting these people in military courts? And the legal advisors did not have a good answer. So I conducted interviews with these people, and I asked them, I tried to discover, how was this court closed down? Why was it abolished? It's only through a different structural understanding of what citizens are and what are the rights of citizens that was affected both internally and externally, in the 1990s that were the liberal years, the most liberal decade in Israeli history after the Oslo Accords, etc. So structural change is political change, and we need a political vocabulary and not a legal vocabulary for.
So it was due to external pressure, plus, the liberal winds of the 90s that got to close the law military court. That again, it was a military court prosecuting civilians, Palestinian citizens of Israel, but that would leave untouched, the military courts that operate in the Palestinian territory. So the legal system is analogous, if you allow me, to say this, it's analogous to the fragmentation and classification, of Palestinians in area A and area B and area C and Gaza and East Jerusalem. So the legal system also operates in these different dimensions, basically controlling demographics, right? You talk about the mechanisms of governability. Can you speak a little bit about that?
Yes, so what I'm saying that normally people, as I said, look at enemies and citizens from the perspective of the state, of sovereignty. So you have borders, who belongs and who not belongs, etc. And I'm saying this is not the only perspective to look at this. So citizenship, again, or animosity, being an enemy, is not only related to sovereignty. That's like the idea of Carl Schmitt saying that the enemy is the essence of the political. What is the political? What characterizes the political sphere is the distinction between friend and enemy. And that is connected to the nation and its sovereignty. I'm saying it also, the distinctions between citizens and aliens, friends and enemies also takes place in other levels. So on the level of what Michel Foucault called governmentality, so the different mechanisms of government that actually manage the lives of individuals on a daily basis. And this is why I look at how citizens, friends, and enemies are constructed through these institutions, through these daily practices that treats them differently on the very basic aspects of their lives. And of course, you can do that with the labor market, the economic market, and many other institutions in society, and see how equal citizens de jure get different treatment de facto. So this is the governmentality lens that we need to use when we talk about these aspects and not stay on the level of sovereignty and the state.
Yeah, because governability in the governmentality lens a la Foucault, what it does is that it stresses the aspect of discipline and control, right? Mm-hmm. So how do you see these evolving, Smadar, at this particular juncture, in terms of the courts, but not only in the courts and on individual cases, but, in the now wider, context that had, changed administrations. We have, for the first time, in the government, partners that were never there.
Yeah, I just want to maybe add just another sentence to my last answer. When you look at it from a governmentality point of view, you see that there are subdivisions within the categories. So for example, in Israel, there is residents of East Jerusalem that are not citizens, but they are residents. There are the settlers. Jewish settlers is again a subgroup of Jewish citizens that they are citizens, but they live outside the territory of the state, and they are treated in some cases differently. So when military courts started to operate, settlers were prosecuted in military courts because they lived in the territories, and they had to struggle and to protest not to be there. So they also negotiated their citizenship rights with the state. So there are these subgroups and divisions within these groups that you see only with a closer look and not in a macro picture. Where is it going now? And what are the aspects? So I think that I already said that the citizenship of Israeli Palestinians has been strengthened along the years. So they have claimed their citizenship rights, and ideas of equal citizenship were strengthened in the 1990s. And Palestinian citizens are still, being discriminated on different levels, but they do participate in political life. It's hard, it's challenging. Their members of parliament are being framed as terrorists and different other things, but they matter. They matter, and what matters is that they themselves take their citizenship seriously and claim rights based on that. What is happening with the occupied Palestinian territories, I think, by now, after hearing your previous talks, but the solution of the two-state solution seems further than ever. And it really is hard to know what is going on. I don't think that this government marks a change in that sense. It marked a change only in what unites the different parts of this government is only the shared will to oust Netanyahu, not to have Netanyahu personally as the prime minister. But then on all other fronts, I don't see a significant change. But it is, political life is dynamic. And in some sense, this rocks the boat, right? We don't know. There are always unintended consequences. And there are different parts pushing in different directions. It's the first time where Palestinian citizens of Israel are part of the government. So there's a party of Palestinian citizens who is a part of the government. The price for that was that they relinquished any demands, any national or collective demands for Palestinians, but only presented demands on an individual level for Palestinian citizens and nothing for the broader Palestinian case. And we should wait and see what happens. It's really hard to anticipate. I do see a promise in the role of Palestinian citizens of Israel who are trying to include and to formulate with some Jewish citizens a vision of a common political community that would be equal for all. And this could take many, many forms of a federation or of a single state with, different federal rules or sub-federal rules that would still allow collective rights to the two collectives that are there. And the two-state solution is also, still a possibility in some sense. It's really, I think we're at a point that it's really hard to say. The Palestinian Authority is in a very hard situation in terms of the trust of the Palestinian people itself. It hardly represents them. There's a great distrust of that Palestinian Authority, both on the political level and on the corruption level. So it's not, the challenges are not only on the Israeli side, there are challenges on the Palestinian side as well. And really hard to say at this point.
Yes, but what you're saying, going back to the core of your research, if I hear you correctly, is that it reminds me, let me rewind a little bit, it reminds me a little bit of Argentina. In Argentina, people say, if you go there every week, everything is constantly changing and everything is chaos. If you go every 10 years, everything's the same. And I don't want to say that that's exactly the same, but it reminded me of what you were saying, because on the one hand, you're saying this is a very novel government, it's unprecedented, but it is defined in a friend-enemy logic as well, right? With the external, Netanyahu. but you don't know how different it is and why, because the emergency powers are still there. And regardless of the government or how the government is formed, right? These very reticular mechanisms are still on the ground operating. So in that sense, there are these continuities that you were marking in your research. On the other hand, what you're also saying is that there are developments, you know, in terms of people getting together, and also among Palestinians, not by chance, you know, the last, you know, Gaza episode may be related to forming a more comprehensive, also symbolic dimension among Palestinians that were, you know, intentionally divided. Right? So these emergency powers, are they being questioned? Are they there to stay? Political, is there any political will that you see forming in this government, given the composition, to dismantle them?
You were asking about emergency powers, and I think we haven't defined them as well in this conversation. So yeah, so in my writing, I frame these military laws as emergency powers because this is their structure. This was their title and structure from the British Empire and on. The thing is that they are not emergency in the sense of temporary and responding to a crisis. They are permanent and there to stay, so they're part of the structure of the system. So what we have been talking so far about as military is actually built on a legal doctrine of emergency powers and on a logic of emergency powers. And you are asking if they're there to stay. So since there has been, to some degree, a differentiation between Israel and the occupied territories. So there has been no change in the way that the military courts in the occupied territories are working. And in their laws, there is a slight change where they become a little more similar to Israeli law because lawyers that are there want to think of themselves as democratic enough, and they have been educated in the Israeli legal system. And as time goes on, they feel uncomfortable with what they're doing and the way it contradicts the idea that they have been educated on. So there's a movement there to resemble the Israeli legal system, but it doesn't solve the structural issues. And in Israel itself, there have been changes. So on this level that we're talking on. First of all, as I said, the Lord Court was abolished in 2000, but the possibility to have this court is still on the books. So the chief of staff can still establish a military court, but I think it tells us a lot that it hasn't happened in the last 20 years, and the chances of this happening are low because there would be significant resistance to that. Additionally, in 2016, Israel introduced a new anti-terrorism law that has, in many senses, replaced the British emergency laws that were in force until then. So part of them are still in force, but others are not. This means that there is a more equal basis for the treatment of these cases, but then on the legally speaking, but then on the individual level, the changes are not major if you look at a case by case basis. But there is a change. I think the main step towards separation and not towards affording more rights was the nation state law that was introduced. And the nation state law defines Israel as the state of the, as a Jewish state, not as a democratic Jewish state. So up until that law, Jewish and democratic had a similar weight in the definition of what that state was. what the nation state law does is to give preference to the Jewish nature of Israel over the democratic aspect. So the law says in many different ways, if you have to choose between democratic and Jewish, you choose Jewish. And that is a major impediment to equality within Israel. And that is a big step away from Israel becoming a genuine democracy.
Particularly, along the lines that you were, developing during this conversation, which is there was already a very strong ethno-national dimension in defining who's in and who's out. So now with the law, it reinforces it more because, the state is expecting, before this law, a commitment to it, this loyalty, and if not, it takes it as a betrayal, and it expects the same loyalty between, Jews and Palestine without conveying or having the same commitment, to Palestinians. And added to that, if a Palestinian is put in a very difficult Palestinian citizen, but any Palestinian is put in a very difficult situation. So they either, this is the self-fulfilling element, if they must be committed to a state that doesn't commit to them, but if they commit to the state, they betray their people. So they either betray their people and their security and a citizen enemy, or they betray, their people and they're seen as, basically traitors and attempting against, the Palestinian people. It's really discouraging. I didn't mean, it's more of a cathartic comment, than a question. So you see the courts evolving along the lines of ethno-national without resorting to creating no military courts for inside Israel. Is that what I'm understanding?
Yes. I think the legal system, the way I described it earlier, the distinction between Jewish citizens and Palestinian citizens was never in the law. It was regarded as a discrimination. And this is why the security service has its own policies that is not on paper to distinguish between Jewish and Palestinian citizens. Comes the nation state law and says Jewish supremacy, says the Jews have favorable status in Israel because Israel is a Jewish state. And so we don't see much of it yet, but this is, we're starting to see it, that the distinction between Palestinian citizen and Jewish citizen can be justified based on that law. So it came on paper. This is now black and white law, and I think it's a radical change in the legal and the political situation in Israel that we're going to see unfolding in the next year. And I have to add that this comes along with a change in the composition of the Supreme Court, a very radical change. So what you have seen here in the Trump era of packing the court with, I say left, right, but you say liberal or non-liberal with non-liberal judges has happened in Israel as well, and in the entire judicial system. And we see the effects of that.
So Smadar, I have a lot of questions. I have way more questions, about the colonial continuities and so much, but I want to be fair. I want to be fair with the audience and allow, their questions. I want to say just that the word that you chose, supremacy, Jewish supremacy, is a very strong one. And it resonates in the context of the US very much. And it kind of brings home everything that you have been sharing with us today. Thank you very much. And I'm going to move to the questions because
I just may just add one question. I say this with, in agony. I'm a Jewish citizen of Israel myself. I want to see my state function as a full democracy and afford full rights for all its citizens. And I'm saying this in pain and in agony, not, I'm not, I'm not happily proclaiming that.
Mm-hmm. Yeah.
It's a sad, I think it's a sad point that we're in.
Thank you for that. Yes. So Robert Tolan is asking, where along the political spectrum do the individual members of the Israeli Supreme Court sit? How many members are there? And I'm gonna ask the other question by Richard Ivanhoe. Are there juries in criminal trials in military courts? Let's start with that.
Okay, so there are no juries in trials in Israel, generally, full stop. Not in civilian courts and not in military courts. Israel does not have a jury system. So there are no juries anywhere. So it's a different system in that sense. The difference does not lie there, let's say. The second question about the Supreme Court, the Israeli Supreme Court has 15 members. It used to be a rather liberal court that used its powers, since Israel does not have a constitution and does not have a formal Bill of Rights. The Supreme Court has done a lot to create what they called a judicial Bill of Rights. And until 1992, there were no basic laws that dealt with the basic rights of individuals. And still there's not a complete a Bill of Rights in Israel and a constitution. So the Supreme Court was very active, or at least defended individual rights. It had a very important role. And in the past, I could say 5 to 7 years, there have been more and more appointments by very right-wing governments that of judges that are more on the conservative side, and that would support the vision of favoring and privileging Jews over other citizens, and would be not liberal in many other ways. So the court had turned the appointments to the court had turned more towards what we call the right. Then not that it used to be on the left, but it used to be at least committed to liberal values, which is now less the case.
Thank you for that. So Robert Toll is also asking, is there any review of military court decision in the Israeli Supreme Court? Is not, what is the highest level of review? And in your opinion, why do Israelis tolerate a military court system that is so unjust?
Many injustices are tolerated. I don't think the military court system is significantly more unjust than many other systems that Palestinians live under military rule, and they need to ask for working permits and stand in checkpoints, etc. So I don't think it's, people tolerate injustice when it's not done to them. That's the truth. So the other community is always more susceptible to injustice, and the majority, puts up or even, practice injustice towards other communities, communities that are not in the majority. This is the answer. There was a first part to the question.
Let me check on the part, but particularly when there are power differentials, yeah. Right? This toleration. What's the highest level of review?
Oh, so that's a good question, because one of the issues of military courts affording less due process rights is that originally military courts had no appeal at all. So there was one instance and no recourse to appeal, and the appeal was introduced only later on, when I said that the military system is becoming a little more like the civilian Israeli system. That was one of the things that were done. So there was a military courts of appeal that was established. So there is another military court that people can appeal to, but then there's no further appeal to any civilian court. It ends there. There's a possibility of petitioning to the Israeli Supreme Court, but that is not like an appeal court. So you can't say, it's not the same terms. You can't say I was punished too much. That's not an argument that you can make in a constitutional case. You have to bring a constitutional or an administrative case, and that was only if the court was acting not within their authority, but not individually how your case was handled. So in fact, there's one military instance of appeal to these courts.
May I follow up on that? Have there been any kind of constitutional reviews of these issues that were not political, as you say, that ended the military court in law?
No. So as I said earlier on, all cases against the court failed. There was one case that was successful that didn't challenge the entire court, but argued that youth, minors under 18 should not be prosecuted in the military court. And that case succeeded sometimes in the 1970s, 1978 or 9, if I'm not mistaken. So from that point on, no people under the age of 18 were prosecuted in the court. So that was a small victory, but the entire structure was never seriously challenged in court and was abolished for different reasons. Regarding the military courts in the occupied territories, again, you can't dismantle a structure by legal action. But there have been challenges. Some of the challenges were presented by me. I submitted 2 petitions to the Israeli Supreme Court, one of them demanding that all the documents in the trials would be translated to Arabic because they were not, and could not understand the language of the documents. That had a partial success. So only part of the documents, the indictment, the charge sheet, is being translated, but not all the documents. Another petition that we had was regarding the length of detention periods. So as a result of that, there was a certain, again, not whole, these are all small steps. So you can achieve small changes, but not a total change. There was a change in detention periods, but they still are very long and very different from the ones inside Israel.
Yeah, before asking another question on these things that are crucial, they all have to be with the rights of the defendants, and that doesn't condone the crime committed at all. So that's important to point out, because many times people conflate, the respect of the rights of defendant with condoning the crime, and so I want to highlight that. So Jonathan Marsh is asking, if Palestinians who are citizens of Israel are dealt with as citizen enemies, how can consideration of the single state solution make sense until this differentiation is abandoned?
Well, a single state solution would be feasible or would be democratic only if Palestinians get a similar status as Jewish Israelis. So the state would have to change in the way it defines itself. It would have to define itself as a state for all its citizens, or as a binational state with 2 national communities. There would have to be differences that would hopefully change the perception of citizen enemies. And, this is not, we're never talking about an ideal solution. The struggles within a political community always go on. So some people will still consider Palestinians as citizens, but hopefully the majority would not. And it's a constant struggle. This is part of the understanding. These categories are dynamic. There has been a change. Their change could go either way. It would still be a challenge and a constant struggle within one state and within 2 states with challenges, with different challenges, to have respect for the rights of all.
Yeah, that's a great point, because there's also differential treatment within Jews, right, between Ashkenazi and Mizrahim, and citizenship is a constant struggle for expansion. You know, we can think about any country, feminist right, women's right, you know, LGBTQ, et cetera, et cetera. So it's important to point out, just not to make it seem that it's only critical of Israel, that, by the way, you mentioned at the very beginning that there are continuities, you know, and it's not exclusive to Israel. So I just want to highlight, you know, that point of continuity as well. So another question is the justice system today the same as in the 1980 cases you cited? And two, do you suffer adverse consequences in Israel because of your work? Those are great questions.
So the answer to the first question is yes and no. Cases of Jewish citizens and Palestinian citizens are still treated differently, but not in the institutional way that it was done in the 1980s. So because this court is no longer operating, for example, these cases are not punishable by the death penalty. So the death penalty for most of the cases is off the table. And these unlimited life imprisonment that Ziada had is no longer practiced in cases that are dealt with today. But if you look at cases of, again, ideologically motivated crime, hate crimes, and crimes that are, in some cases, terrorist crimes, these are treated very, very differently if the defendant is a Jewish citizen, and in most cases, settlers. So settlers are the main group who would commit crimes against Palestinians, and there are cases against them, and you see the treatment is very, very different between them and between Palestinians, either citizens or non-citizens. But some of the formal structures that used to hold this together are not there. So it is more open to contestation, I would say, but it's still very much present. So you see that with treatment of children, for example, settler children who would throw stones or even, or harm Palestinians in different ways, would be released after 24 hours and bailed out, while Palestinian children will spend months in detention before trial and then sentenced to months or years. It's the differences are still very pronounced.
My question, Smadar, one of the questions that I ask myself when listening to you, like, in terms of the crimes, right? Like a murder, let's say, like, how do you determine, or how it is determined that is ideologically or hate motivated, or not? Because from what we have been discussing, I would assume, or infer rather than assume, that if it's a Palestinian citizen who kills a Jew, that is automatically a hate crime, right? Whereas in other societies, of course, there are homicides. I don't want to say of course, but there are homicides that are not necessarily assumed to be hate crimes, right?
Yes. In Israel, it would be framed as terrorism and not as hate crime in most of the cases, but there's this and that. Yes, I think you are right in the sense that there's a very strong assumption that if crime is committed by a Palestinian towards a Jew, there's an assumption that it was ideologically motivated in either terrorist or hate crime. But there are other circumstances. So how do you decide? Many times there is a confession. People say why they did it. If they just went out and looked for anyone who was Jewish and to harm them, then that assumption is true. And then it's also on the other side, on right-wing and settler violence. So if you were looking for a Palestinian to hurt, and that was your category, so it's motivated by hate or by a political, ideological motivation.
So they're political crimes.
Yes. Yeah.
So they are understood as political crimes because the enemy penology versus like the criminal law.
Mm-hmm.
I mean, in this case, could be understood as like political crimes versus like regular crimes, right? And there's an assumption of enmity, and enmity going back to Carl Schmitt, in which, you know, the existential threat is the political.
Yes.
Right.
You can see that, for example, if you think about Palestinians who are involved in car accidents or not. So and that happened many times in Jerusalem and in the West Bank. A Palestinian driver hits a Jewish bystander. Was it an accident or was it intentional? So Palestinians run the risk of always being assumed as being a terrorist. And in many cases, when they do get into a situation of an accident, they could be shot because they're by soldiers or policemen who are there because they are suspected as have just committed a terrorist attack, while it could be just an innocent accident, and that is very hard to tell them. But the risk exists for Palestinians and not for others.
That's an excellent example of the kind of permanent, I'm going to use this word, right? Terror, right? Of making a mistake that Palestinians live under, right? And I mean, and I chose the word carefully, but it is. I want to go to the other question that Robert asked: do you suffer adverse consequences in Israel because of your work? And also there's a comment by Jonathan Marsh: I believe there is a substantial population of Palestinians in Jordan. Do you know if there is a similar differentiation structure there?
Okay, so the question of me suffering adverse consequences, I would say they were minimal. Again, I'm a Jewish citizen, and Israel affords its Jewish citizens great degree of civil liberties, and I have enjoyed that. I did receive threats and hostile treatment when I was defending Palestinians and other supporters of Palestinian rights. But that was not, I don't feel that it affected my life very significantly. I can say that I'm in the US for the last 5 years. So haven't been in Israel, and the political climate has changed. And I feel that my colleagues and people in human rights organizations that are more, I was treated as an individual lawyer, and an individual lawyer kind of in the liberal understanding has a right, and the client has a right to be represented. So that's one framing. If you look at human rights organizations, with which I work a lot, and I'm on the board of organizations and I do work for them, they have been subject to very, very serious limitations. And on that front, they're very, nearing persecution of people individually and as organizations. So changing the rules so that human rights organizations can act, they have to declare their funding, all kinds of limitations have been put on them in the past years. So in that sense, I think there is a framing of human rights activists and organizations as traitors, and that has become stronger in the last 10 years, perhaps. I should say that in some senses, in some ways, it's harder to talk about Israel. It's harder to criticize Israel in America and to an American Jewish audience than it is in Israel. It is paradoxical, but it is what it is. And the second question. was what?
About Jordan, about the status of Palestinians in Jordan, whether there are similar structures.
Yes, there are. So I will not say that they're similar because they're different, but Palestinians are not being treated equally in Jordan. They are discriminated against. Their citizenship is not full citizenship. In other Arab countries, the situation is similar in Kuwait or in Saudi Arabia, etc. So Palestinians are not, they suffer because of their status in many Arab countries and not only in Israel.
Yeah, in Lebanon, needless to say, they don't have citizenship status, and they have like a complete different set of law that regulates even access to work. You know, besides, you know, Sabra, Shatila, and the refugee camps. Yeah, what I want to also mention about, you know, your work is that, you know, in this is the colonial issue that we have been discussing, you know, in the previous, you know, sessions, and then you bring in a new angle to this colonial dimension. It's usually not, you know, good PR for Israel saying colonial, because that would entail that, you know, Jews are not rightful claimers, you know, the land, or they do not have an attachment, you know, to the land. But you bring the colonial dimension, you know, for the purely kind of legal perspective, you know, showing this colonialism in the continuity with the British structures, as you have pointed, you know, at some point. And I want to bring that point because I think it's very important in make the picture more complex and not kind of slogans, colonial, yes, no, right to the land, yes, no. Let me see whether there are more questions, Smadar, and if not, of course, you have the last word if you want to add something. So no questions in the chat.
Okay, good. Yes, I first of all, thank you for inviting me, and it was a pleasure to converse with you and with your audience. The colonial aspect is important, and you are right that I bring this not, you know, it's not in a polemic way. I study legal systems, and I see the way that Israel is using the law in the way that colonial powers have used the law. So I'm not talking about, you know, I'm not a political scientist. I'm not talking about the origins of the Zionist movement, etc. I'm looking at how does the Israeli state function. I'm not just looking at, you know, on a macro level. And when I compare Israel to other countries that have been British colonies, all of these countries upon independence have civilianized their justice system, have got rid of military courts, and have got rid of the death penalty. And Israel did not make this transition post-independence. It did not make the transition to post-colonialism because it maintained a colonial project of its own. So before 1948, there were the British colonialism and the Zionist colonialism taking over land, etc. And after 1948, the British were gone, but there was still a colonial project going on. And like you mentioned, these mechanisms were used to take over land of Palestinians and to restrict the access of Palestinians to the land. And going on, it was again used to confront resistance. So resistance is there when colonialism is there, and it was like that throughout history. So I do show how not only there are colonial origins, again, in the structure of the legal system and the laws, but how they are constantly being used and deployed again and again, and not only there as an inheritance. And it's, like, you know, it's important to have this this larger perspective on what we're talking about.
And I thank you, Smadar, so much for that, because you hit tensions and contradictions head on. I mean, things are not one way or the other. You bring tensions, you know, in the dimension of colonialism, also in the legal system, also inside and outside. And these are these things that we need to confront if we want to really understand the reticulars and how to move forward. So I thank you so much for this very illuminating conversation, definitely for me, and I'm sure for all the audience. Thank you very much for being here. I invite everyone to join the discussion session later. And I look forward to more work coming from you. You have articles being published very soon. I would like the citations to share with the audience.
Yeah.
I'm putting
It's all
resources
available.
together.
It's all available on my academia page and my SSRN page. So I can share the links with you and people can read if they're so inclined.
Wonderful, Smadar. Thank you so much for this.
Thank you. Thank all.
Thank you.